If you've been injured and you're considering filing a claim, maybe you're worried, does this mean I have to go to court? Hi, I'm attorney Jim Curtis. There's a lot of confusion out there with clients telling me all the time that they're reluctant to pursue a claim because they don't want to go to court and that just filing a lawsuit is like stepping on a courtroom stage. So today, I want to set the record straight and help you make sense of what filing a personal injury claim actually means, when a lawsuit is required, what happens when you do file suit, and why sometimes, believe it or not, going to court just isn't the right move. So let's dive in. First things first, just because you file a personal injury claim, that does not mean you're automatically heading to court. Most claims, around 95%, are resolved through settlement, not through trials in court. A claim simply kicks off the process. You let the insurance company or the responsible party know that you're seeking compensation. From here, the negotiation process begins. Your lawyer gathers evidence, handles paperwork, and negotiates with adjusters. And more often than not, both sides come to an agreement outside the courtroom. That's the settlement you hear about on TV or from your neighbors. Quick, efficient, and confidential. But you might ask, when does a lawsuit become necessary? Sometimes negotiations with the insurance company don't produce a fair offer. Sometimes there's a dispute over exactly who is at fault, or there are questions about the amount of damages owed. Maybe the insurer is refusing to compromise, or new facts come to light that change how your claim is viewed. If your claim stalls, or if you're offered something far less than what you deserve, then filing a lawsuit is your next step. This kicks your case into a more formal phase, the legal system. Now, both sides start gathering evidence, exchanging information, and working their way through the pretrial process. Filing suit doesn't mean the next stop is the judge's bench, though. There are still plenty of opportunities to settle. But here's the big misconception. Filing a lawsuit does not mean your case will end up in trial. In fact, even after a lawsuit is filed, settlements happen all the time. Why? Because court trials are expensive, time-consuming, and unpredictable for both sides. Judges encourage settlements, lawyers negotiate right up to the courtroom steps, and parties frequently find common ground to avoid the cost and stress of litigation. So even if your case seems headed for court, most likely it'll still be resolved with an agreement. Statistically, less than 5% of personal injury cases actually see a trial in front of a judge or jury. Everyone else settles before then. Let's be real though, there are times when filing a lawsuit is not the best move for your case. Maybe your injuries are relatively minor. Maybe the costs and delays of court proceedings would eat up any gain in compensation. Maybe the party at fault has very little insurance or assets, so a judgment would be hollow. Sometimes, dragging a case out in court brings more stress and expense than resolution. Your lawyer's job is to weigh these factors to advise you on whether settling outside the courtroom is actually the smartest path for you. A skilled lawyer always prepares every case as if it might go to trial, but also knows when to step back, accept a fair settlement, and help you move forward with dignity. So if you're considering a claim, remember, every case is unique, and court is not the automatic destination. Now that you know what it actually means to file a claim or a lawsuit when necessary, and that it isn't just an automatic ticket to the courtroom, be sure to check out this next video to learn about 5 of the insurance company's most favorite arguments that they love to use to minimize your claim. See you there.